Ms. Hackle,
Hi. Hello. The authorized representative for Hackle is here.
please turn your camera on, please.
Okay, I have to access it, so it might kick me out. So I'm gonna do it now.
That's fine.
Okay.
I know I denied the motion to set aside the default judgment back on August 21st. Defendant failed to appear.
Correct.
Defendant's motion to seek leave of court is denied.
We're showing a current, although this is a termination of tenancy for failure to recertify, we show a balance of in excess of $12,000.
Ms. Hackle, state your name for the record.
I am the authorized representative for Alicia Hackle.
I don't see your face. I'm sorry. I see your hat. Let me see your face.
Oh, okay, I'm here.
The camera's pointing at the top of your head. I can't see your face. All right. Mr. Hoop, go ahead.
Yeah, thank you, Your Honor. A judgment was entered, a motion was denied, trying to set aside the judgment. Plaintiff is seeking a order of eviction for termination of tenancy. No payment has been made since March of 2024. We would ask that a writ be issued.
So the writ will issue and execute immediately.
Thank you, Your Honor.
I would like to say there's been a defective order of process. I never received a motion for today.
The video opens with a woman claiming to be the authorized representative for a tenant named Alicia Hackle, but the judge isn't buying it. He quickly points out that Hackle already defaulted on the case after failing to appear for earlier court dates. He tries to argue that she never received the proper documents, but the court confirms service was completed correctly. Her objections dismissed. She throws out a flurry of procedural complaints, but none of them hold up. In the end, the judge calmly but firmly issues the writ of eviction. It's a textbook sovereign citizen eviction defense. Lots of legal-sounding jargon and absolutely zero success.
Ma'am, what's your name? You said you're a representative for Alicia Hackle.
Yeah.
What's your name?
I never received the order of process for court today. I went down to the court today and she gave me the documents for court today. There's also isn't a sign off by a judge on the document sheet that she explained to me that the judge didn't even sign the documents. I also never received a motion in the mail.
Well, this is an application. There is an application for eviction.
Yeah, there's an issuance for a writ here. I've actually never received that so that I could formally respond to it.
All right, so let me make a record. Give me 1 second.
Yeah, there should be some proof of service in the files for the case.
Well, hold on 1 second. 1 second. You were served with the summons and complaint. It was posted on the address by Chief Officer, Court Officer Juan Polanco. I believe he did it on July 20th, 2024. And then there was a default judgment entered against you by Judge Goubeau on July 31st, 2024. I believe you failed to appear. You didn't appear to that. And so that's how we get here now. Then you filed a motion to set aside the default judgment. Hold on 1 second. And you did not appear to the default judgment. So, yeah, the writ in issue. So you've been advised of court and you failed to appear twice. Like, I'm not understanding what's going on.
I actually
so
all my documents. I've given all my documents. There was a judgment issued against me. And it was denied. But and then after that, I hadn't received anything back for the case until I'm in court today about something that I had gotten no prior documents before I came to court today. I literally didn't receive any motion for issuance for a writ until today when I went to the court to get the papers. I didn't receive this by mail at all, so that I would have been able to respond to it before now.
Your Honor,
I
I
have
think
not
I
missed
heard
any
your,
case. I have not missed any court dates.
Your Honor, I heard your ruling. Thank you very much.
All right. Thank you. We're all set.
Have a good day.
You too. Thank you. You got to move out, Ms. Hackle. It's just that simple. Sorry.
The woman keeps insisting she was never properly notified, even though court records show multiple documented attempts to serve her. She claims one of the court orders wasn't personally signed by the judge and says she only received the paperwork the morning of the hearing. But the court isn't swayed. The judge explains that at this stage, the eviction is purely procedural. She missed her chance to argue when she failed to show up earlier. Her last-minute strategy, throwing legal confusion into the mix, falls flat. The result? Immediate execution of eviction. She's out of legal options. And soon, out the apartment.
Myrick, good morning. I've got this set for a pretrial. Now, I have a note here that said that you were not interested in court-appointed counsel, which is fine. So basically, at this point in time, it's a pretrial. So I would set you up with a breakout room with the prosecutor to see, what if they have any offers or what their story is. I just want to make sure when you go in there, like you don't have an attorney with you and they're the attorney on the other side. They may give you an offer that you like, and that's fine. But I just want to make sure that that at any point in time, if you don't like the way the conversation is heading, if you change your mind and you do want to come back and ask for an attorney, just come back and let me know. Okay.
Okay. Before I get into the breakout room, Your Honor, I do want to address we are in the pretrial stage, and in the arraignment stage, I was entered a plea involuntarily. So I would love to have an ample amount of time to draw a meaningful defense. If anything, there was some questionable things that the last judge mentioned that I haven't found at all as far as a statutory jurisdiction. But I would like to have time to draw a meaningful defense as well.
Okay, so do you not want to meet with the prosecutor then?
Well, I don't think it's completely prudent right now, simply because we haven't technically went past the arraignment stage of this process. I feel as if my due process has been violated. Fifth and 14th Amendment. I didn't enter a plea, and here we are in pretrial. So I would like to kind of digress a little bit and have at least enough time to develop a meaningful defense.
Okay, I guess I'm a little confused. So you had an arraignment date, and
Yes.
at that arraignment date, did you refuse to enter? Did you refuse to enter a plea? Because that's the time where a plea of some sort has to be entered. So at that point in time, did you, of your own volition, say, I'm not saying anything at all?
Well, that wasn't totally the case, but I didn't have understanding of what court I was in. And I didn't understand if it was a criminal jurisdiction, civil jurisdiction. And based on the at least the federal laws for sure, we didn't come up to an understanding. So
we shift to a familiar face, a self-proclaimed sovereign citizen who once ranted about his right to travel. But this time, there's a twist. He walks into court ready for battle, only to learn his case could be resolved for just $50. Suddenly, the sovereign's script disappears. He still tosses out a few claims about due process violations, but the judge isn't buying it. Despite that, the court shows remarkable patience, acknowledging his consistent appearances and even reducing his bond. The takeaway? Drop the theatrics, and the court might just meet you halfway. Next, voice 4. The judge takes a moment to review the man's court history, and surprisingly, gives him credit. Despite past non-compliance, his recent good faith appearances earn him a break. The bond is amended not as punishment, but as a gesture of trust. And for the first time, he listens. The court lays it out plainly. Pay a $45 fine, and you could be on the path to getting your license back. It's a real-time reminder. Courts aren't out to crush people, but you have to meet them halfway. Drop the resistance, start cooperating, and things can actually move in your favor.
Arrested and they're sitting in custody, okay? Or if they've received a ticket or some sort of notification. So you just said to me that you didn't even know what court you were in. So I just want to know, like, how did you know how to get here? How did you know how to zoom in? Because the Zoom information contains all of our like what court it is, what magistrate, like all of that's contained in there. So I just how did you know otherwise?
No, I did receive a ticket, and I got notice. But what my issue was appearing here on special appearance today, and I needed to get understanding of what jurisdiction I was in.
Okay, all right. So because I definitely want to make sure that people know where they're supposed to be. So I think I'm looking at the same ticket that you had. So it says on the ticket, 44th District Court, Royal Oak, and then the court address is on there. And then you said that you received notice. So the notice that went out, it would have had the Zoom instructions. Again, Mr. Myrick, as you can imagine, we are, I'm always very concerned in making sure people have the proper notification and all that. So it does appear that, I mean, you're here a second time. The only thing that I was, now looking at the file here, you were ordered to post a bond and you didn't. Now, I'm reading the notes here. It says there was a bond of 1,000 cash surety, no 10%. So $1,000 bond was expected to be paid within 48 hours. Now, Mr. Meyer, we're here today. You showed up on time. So one of the reasons that a bond is ordered is, one, for the safety of the community, and two, to a secure appearance. Well, you come here a second time, and so I am very comfortable that you are going to continue to show up. So I, at the very least, for you, Mr. Myrick, today, as long as you continue to abide by the expectation that you'll show up, and you have twice now, I'm going to actually amend that bond. So that even though you were supposed to do it within 40 hours and you didn't, okay, the fact that you showed up here again, at least to me, is enough evidence to suggest that I can count on your appearance going forward. So
that's righteous.
The judge takes a moment to explain Operation Drive, a community program designed to help people restore suspended licenses. It's not a trap. It's a lifeline. The goal isn't endless punishment, but giving folks a real shot at getting back on track. And this time, the sovereign citizen actually listens. He hears the message loud and clear. The court isn't out to ruin him. It's offering a way out. He even compliments the judge's fairness, a rare moment where the sovereign delusion gives way to reality. And honestly, it's refreshing to watch.
And what I'm ultimately asking, Your Honor, is that if I can have more time to, I don't have any discovery. I don't have what I need to assess to move forward. So if I can have more time,
I have no problem adjourning the pretrial so that you could do some more information gathering. Just to let you know, Mr. Myrick, again, like our court, as you can imagine, with 696-75 Woodward, we have a lot of traffic misdemeanors that come through this court. And one of our signature programs that we've been doing for the last 8 years is, trying to really help people, because I would imagine that you pay attention to the challenges of the Metro Detroit area and public transportation issues and people's ability to get around, and how many people over time have got themselves in the cycle of they have to drive, but they pick up a ticket and they can't pay that ticket, so the license gets suspended and they get stuck in the cycle forever and ever and ever. Okay. Well, in our Operation Drive program, what we've done over the last 8 to 10 years, we're keeping stats since March of 2016. So in the last 9 years, we're over 1,700 licenses restored. So like that's something that we try to do, is make sure that we inform, educate, get people the information that they need, which Mr. Myrick, you could probably imagine, for years and years, the court system hasn't been great about letting people know even where to start, how to get their license. So
Yes,
in
sir.
the meantime, while you're doing your investigation, I at least want to let you know what's on your record so that you can at least know, because some people don't even know like where to start, how to go, or what
Yes,
what
sir.
to do. And
And
the law
I
has
greatly appreciate you.
and the law has changed in a significant way. It used to be that every single little ticket that you'd get would suspend your license. Now it's only a couple tickets here and there that do that. So
I'm very honored, Your Honor, to be in your courtroom. I think you're the one that I've heard so much good news about, goodwill and good-hearted judge, that assists the public to oppose to the opposite. So I truly appreciate your efforts here. Thank you very much.
The moment of realization finally hits when the clerk confirms his fines might be as low as $45 per ticket. You can see it on his face. This isn't some grand legal battle. It's just easier to resolve the issue than keep fighting it in fantasy court. Even better, the judge acknowledges the outdated fines and offers to personally follow up with the Secretary of State to get his license status updated. Cooperation just earned him something sovereign citizens rarely get: real freedom. Not the imaginary kind wrapped in pseudo-legal nonsense, actual practical results.
But you're thinking it's an NPOI?
yeah, it should be an MPOI.
All right. Because there
No
are
proof- no proof
tickets, all of
insurance.
which are showing 45s. So let me-
Really?
Yeah. So let me look at the second one. Sorry, it's taking so long.
That's all right. That'd be great
All right.
news because that'd be just $45.
No proof of insurance. This one was a default judgment. It is showing $45. But it is showing a bond that you posted, sir, back in 2009 of $398. I think they took that, so perhaps they applied it to that fee, and they just want the 45. That may be the answer on that one.
So okay. So best case scenario, they'll let you just pay the 45. Okay. Worst case scenario, they'll want the $45 on each of the old tickets, so $135. So best case scenario 45, worst case scenario 135. But that's Allen Park.
Wow, that's great.
And that's 24th District Court, sir, if you're looking it up.
24th District.
And it's interesting because these are very old cases, but the close date on the third ticket is 2017, and now I'm getting error readings. So, but there's just 3. Looks like you had your bond taken on the no proof because perhaps you didn't go back, and that may satisfy that.
All right. So Mr. Myrick, so here's what we're going to do. I'm going to bump this out a couple weeks. You get to work chopping away at that kind of stuff. But I will say this. I only want to bump it out a couple weeks because if you get those things done, all right, I want you to come back and see me. We'll be able to run a new driving record. We'll see if by doing that, all right, that they follow through and let the Secretary of State know. Because if they take your money and they don't let the Secretary of State know, then the suspensions remain. And then we can even contact the Secretary of State and just make sure that they know, like, oh, by the way, he paid those.
Right.
And then when you come back here, you can give me an update. But just know, if you've paid those 2 tickets, you should be able to go into the Secretary of State and pay the reinstatement fee and go from there. So what do you think? A couple weeks?
Safely to say, I would say 30 days. If I can have the grace.
No problem. No problem.
Thank you, Your Honor. I appreciate you dearly too. Thank you very much.
You're welcome. All right, so we'll adjourn this 4 weeks, and we'll send notice again. And then just do me a favor, Mr. Myrick, if you run into issues, I'm gonna send you our direct line here at the court.
Thank you very much, Your Honor.
And for example, if you do decide, if you're running into issues, I certainly can connect with Mr. Angot, Ms. Chappelli there. Mr. Angot's our MIDC coordinator. I know that you initially were not inclined to go with assigned counsel, but what Ms. Chappelli's doing today is exactly what would be done. So if you just reach out to us, let us know, like if you're running into brick walls and you say, like, I would like an attorney attached to this case, then call us and we'll get it done.
The judge sets a 4-week continuation, giving the defendant time to clear up any remaining issues. But he doesn't just send him off. He reminds him to reach out if obstacles come up. The tone is respectful, constructive, and firm. By now, the defendant is fully engaged. He's not resisting. He's ready to fix things. And it's a solid turnaround from where he started. It just goes to show, when you drop the courtroom theatrics and show some respect for the legal process, it still pays off.
Court calls People versus Ryan John Hart, file 24-4935FH.
Your Honor, Ryan Ziegler on behalf of the people.
Thomas Seeger appearing on behalf of Mr. Hart.
I have somebody in my hearing room listed as Ryan Hart. State your name for the record, please.
My name is Ryan John Family Hart.
I don't have anyone on my docket listed as Ryan John Family of Hart. I have an individual listed as Ryan John Hart. That's either you or it's not. You get to tell me whether or not that's your name. If it's not, then I need to call a different matter and bring somebody else into my hearing room.
Your Honor, I'm the representative of that entity, yes.
That's not an answer, sir. Your name is either Ryan John Hart, in which case you're invited to participate in the proceeding today as Ryan John Hart, or you're not Ryan John Hart, in which case I have no use for you to be in this hearing today. So tell me your name so that I can determine whether or not you're the proper person to be called in this case.
My name is Ryan John Hart. May I ask a question, Your Honor?
Now we meet Ryan John Hart, though he insists he's not a person, but the family of Hart. It's Sovereign Citizen 101. Dodge accountability by rejecting your legal identity. The judge gives him a chance. Just say your name. But Hart dances around the question with semantic gymnastics. The court isn't playing. The judge sees it for what it is. A stall tactic wrapped in legal-sounding nonsense, and he shuts it down fast. No theatrics, no sidebar debates, just forward momentum and firm control of the courtroom.